Pedro, estás-me a ouvir?
Exatamente.
Não se ouve rigorosamente nada lá do sítio.
Mas eu acho que é porque está sem som de propósito.
Ah, ok. Ok. Estás bom?
Okay, we should start probably. Hi everyone, especially
Hi.
you who are online today. This is the third jam session of our this week's legal philosophy meetings, and today we are having it in a kind of a, I mean, we did have it previous 2 days also in hybrid format, but today, since our speakers are unfortunately not with us, we are having more people online, but we do have some people here in the room, in a smaller room, but the one who is dedicated to this WebEx meeting. So, as you all know, our speakers today are from the Lisbon Law Faculty, that is from the Lisbon Legal Theory Group, and it's my great pleasure to welcome David Duarte and Pedro Moniz Lopes. I think that we will start with David, am I right? Or
Yeah, I may start.
okay, so as we said, it's completely open for different styles of contributions. That is, some of the presentations were more structured, some were more kind of in the form of dialogue and conversation with participants. So it's completely up to you. How would you like to proceed? So David, we haven't talked about what you intend to do, but I'm sure that you will do it in the best possible way, as always.
Hello, my dear friends. It's so nice to see you, even though not presentially. I would like so much to be there, but as you know, I am in a very, very far away place. As you know, I am a very rigid and square person, so I will do it the hardcore way, which means that I have a PowerPoint presentation. Can I share it with you? Or do you allow me to share it?
Yeah. Do you need, I think I made you, okay, maybe Pedro. Hi, David. Very nice to see you.
Sorry?
Yeah, you should be able to share it. Wait a sec. Unfortunately, our IT is not here with us today. Oh, yeah.
So I'll take the meantime just to say hello to everybody. Miodrag and Boyan.
Hi, Pedro.
Hi. I'm very, very sad not to be there, but I'll be there very soon.
David, you're definitely allowed to share the presentation
using the button share.
As
the button share tells me to open system preferences, and when I open system preferences, nothing happens. So I think probably we could do the. Do you know how to solve this? I never used this.
Do you have it already open at your computer?
I already. What do you mean? The presentation?
Yes. If it's open at your computer, you have the button share, which is offered on some sort of how do you call it? This tab
right
with all the
volume
functions.
button. like a rectangle with an arrow?
Yeah, but I do it and it says open system preferences.
Are you on a Mac?
Yes.
Because sometimes Macs need the applications to be authorized to share the content of the screens.
David,
Yes.
share it. Could you send the presentation to my email, and I'm going to play it?
Yeah, that's the plan B I was thinking about. And you just put it there.
Let me just.
While the presentation is coming, you can like tell us a joke or sing something if you like.
Well, boy, and I already sent it.
Yeah.
I would love to be skilled enough to sing, but it is not the case. So
Go for the joke.
yeah, I probably will go for the joke.
I'm sure you had plenty of jokes there in America.
Yeah, you have jokes. You should have.
They are funny people. They are very funny people, Americans.
Indeed, very funny people indeed. Okay, so if we are going to do this way, you will start to project the presentation over there, and I will ask you to move pages. Is it okay?
Yeah, just have to figure out how to do this because I'm not connected at the same time. I know she also share the screen. Wait.
Can you log on to your email on the computer that's doing the WebEx?
Depending on which email was David sent it to me. It is. It's for you. Then yes. Probably yes.
What is that sound?
It's a bell.
Yeah, it was repeated like all the time in these last days.
It's a
No,
bell.
I'm sorry for this.
And the photo
You want
No,
to
but-
start?
in high school. It's it's uncommon even at no other faculty has bell.
Okay, now
we
I
are the only
understand.
one with the bell.
Because it was like
Miodrag, I just can't avoid to say that you are very, very elegant today.
something.
What?
Thank you.
Hi, Julieta. I hadn't seen you here in the camera. Now I saw you.
Hello, how are you? Where are you?
I'm sadly in Portugal, not in glamorous California, and not in glamorous Belgrade.
And you burned all your books from the shelves.
Yeah, there were. Yeah, I'm Miodrag. I'm starting over.
That's a good thing.
Okay, fair enough.
Start from the scratch.
Okay,
Okay, he managed.
so I can start speaking. Can
Yes.
I?
Go ahead, please.
Okay, thank you very much for everything. This is the first academic kickoff of the project. I can continue without saying that I hope for the success of this project, namely because it is going to be carried out among friends. And I decided to choose, not so fast, please. Let's keep on the first one. Thank you. I decided to kick off with the deontic modalities thing because I've been puzzled in the last years with the fact that I see undergraduate students finishing their degree without studying the square of deontic modalities or even having ideas about deontic modalities in themselves. And I think this is quite puzzling because this is our core business. When we look into the distinction between is and ought, and we know that we do not live in the world of the is, but we live in the world of the ought, we should be very aware that deontic modalities, it's the floor upon which we pass through. So please, second slide. Okay. As I said, deontic modalities are the core of law because they express the very core of normativity. They constitute in itself the regulation of behavior. Because as we all know, not to connect an action type to a deontic modalization. We have some sentence saying that it is forbidden to kill. We will immediately see that there is an action type, killing, and a deontic modality, to be forbidden. If we look into a very basic norm structure, we will see that this norm structure only has descriptions. Some antecedent, which refers to some event type, some occurrence, and the consequence, that is the action type in itself. And that makes a reference to some individual act to be performed by some subject. So it is the deontic modality that gives normativity to norms. And it is the deontic modality that expresses law as something belonging to an ideal world and not the real world we face in our daily lives. Next one, please. Okay, we usually recognize three deontic modalities: obligation, for short OX, which means that this action X ought to be carried out; prohibition, action X ought to be not carried out; and permission, action X may be carried out. I'm now, as we will discuss later on, just making reference to the semantic notion of permission. And as we all know as well, deontic modalities are interchangeable, which means that using negations, we can write the same kind of regulation of behavior with different deontic modalities. Just as an example, the obligation of X, it's equivalent to the prohibition of non-X, which is equivalent to the non-permission of non-X. And it follows to all the others. Next, please. Well, logical relations between deontic modalities are built on the relations between alentic modalities. What do I mean? What it is meant by alentic modalities are the modalities which refer to necessity and possibility, which is they refer to something that is true or false, but embedding what one says when referring that what might be or might have been the case. Why am I making reference to alentic modalities? Because the first logical relations between alentic modalities were written in the Organic by Aristotle. And then in the Middle Ages, some philosophers like Abelard and St. Anselm, and then Leibniz, of course, some centuries after, have seen that the logical relations between alentic modalities are quite the same that the ones we can figure out about the deontic modalities. So, based on the relations of alentic modalities, we can have some logical relations between deontic modalities. And as you can see on this square, we have up left necessity of X, and then impossibility of X, the positive possibility of X, and the negative possibility of X, which is a possibility of non-X. And these are relations that are accepted as axioms between these different alentic modalities. Next, please. These relations are implication. One implies the other. So the necessity of X implies the possibility of X. I'm sorry. Contrariety, which means that two of them cannot be both true, but they can be both false. The necessity of X and the impossibility of X cannot be both true. Subcontrariety, they cannot be true, but cannot be both false. Positive and negative possibilities of X can be both true. And contradiction, if one is true, the other one is necessarily false. Next, please. Can you just move on, please? Okay, let's look into the square. Now we changed alectic modalities to deontic modalities. We have the obligation of X and the prohibition of X. They are contraries, which means that they cannot be both true, but they can be false. Then we have the relation down the square of subcontrariety between the positive permission and the negative permission. They can be both true, but they cannot be both false. Then in the lateral sides, we have the relation of implication. The obligation of X implies the positive permission of X, and the prohibition of X implies the negative permission of X. And inside the square, we have the relations of contradiction. So when X is forbidden, the contradictory is the positive permission of X. And when X is mandatory, the contradictory is the negative permission of X. The next one, please. So, and in sum, related to what has been said, the obligation and the prohibition of X are contraries. The positive and the negative permission of X are subcontraries. The obligation of X implies the permission of X, and the prohibition of X implies the negative permission of X. And then we have the contradictories as we saw. However, I'm sorry for this. However, when we look into this square, we see that differently from our usual parallels, we don't have 3, but 4 deontic modalities, because permission is divided into 2 different ones, the permission of X and the permission of non-X. Next one, please. So this leads us to a very serious problem, probably the most complex problem in what regards deontic modalities, which is the ambiguity of permission. The word permission is particularly ambiguous because there are many several senses in which we use the word. And there are many different classifications of permissions. And when we use one of the terms of these classifications, we are obviously using different meanings of the word. We listen about strong permission, weak permission, unilateral permission, bilateral permission, complete permission, incomplete permission, and so on and so on. But already from what has already been shown, we already have 2 meanings. Unilateral permission, that is usually called as logic permission, is the case when the deontic mode only covers just one version of the action type, either X or non-X, doing or not doing, and it is mute regarding the contrary act. To make it more simple, the unilateral permission is the case when the system says that I'm allowed to smoke, but it does not say anything about non-smoking. So it only regulates one of the 2 versions of the action type. But then we have a totally different sense of permission, which is the bilateral permission. We may call it the semantic notion of permission. And in this sense, the permission covers both versions of the action type. Both X and non-X are permitted. In this sense, a permission is a deontic modality that allows me to make a choice regarding my behavior. If it is allowed to smoke, I know that it is also allowed to non-smoke, so I have a space of autonomy inside which I can decide how to carry out my action. Next, please. However, only taking into account these two very specific meanings of permission, we have to be practical and we have to pose the question, which kind of permission is the permission that is enacted by normative authorities in our normal legal systems? When we look into the Serbian constitution and we see that some action type is permitted because the legislator, when the constitution was enacted, said that this action is allowed to all citizens, we have to know if he's making reference to permission in the unilateral sense or in the bilateral sense. And my answer is clearly bilateral permissions, which is the semantic notion of permissions. And I think three arguments sustain this statement. First argument. The community of speakers assigned the bilateral meaning to the permissive verbs used by authorities to modalize action. So it doesn't matter which is the natural language at end. I'm sure that in Serbian, Croatian, or in Portuguese, or in English, or whatever, when the normative authority says that this action type is allowed or is permitted, or people can carry out, and so on and so on. What the community of speakers assigned to this sentence, and specifically to the verbs that represent the deontic modality, is the bilateral meaning of permission, which is that once X is permitted, non-X is permitted as well. So I would say that linguistically, permissions are clearly bilateral. Next one, please. Second argument. This is an argument that has been developed by Ratti, Giovanni Battista Ratti, from our colleagues of Genoa. And I think it is a very, very strong argument, probably a fatal one. Well, let's see the following. If a normative authority only permits X unilaterally, if we pose this possibility, one does not know the deontic status of non-X. But under the square of deontic modalities that we just looked before, if X is permitted, then there are only two possibilities for the deontic status of non-X. The first possibility, the first option, is that non-X is also permitted. And the second possibility is that non-X is not permitted because it is mandatory. But the second option has very absurd results. It implies, given the rule of contrariety between mandatory and forbidden, that X is mandatory. And this implies that X would be being imposed with permissive verbs, which is, if we go to the second option, that non-X is not permitted, logically, this will imply that when the normative authority is saying that you are allowed to smoke, actually the meaning would be you are obliged to smoke. And this is totally devoid of sense. And such absurd result leads us to have to take the first option. So when the normative authority permits X, the deontic status of non-X, it's also a permission under the penalty of an absurd linguistical result. And there is this third argument, which I think it is relevant as well, that if X is regulated and non-X is not, then there is an absence on the deontic status of non-X, which means that there is a pragmatically equivalence of non-X to being permitted. Next one, please. So, all these taken into account, I think we may assume that in normal legal systems, in the systems we deal with in a daily basis, the permission is used in the bilateral sense. So this can lead us to make the triangle reduction, which is something that has been developed, for instance, by Andrew Halpin. And the triangle reduction points out to different kinds of logical relations. We have the obligation of X, the prohibition of X, and then the permission of X and non-X, which makes us assume that there are one contradictory relation or one relation of contrariety and two relations of contradiction. Next one, please. But since contrariety between the obligation of X and the prohibition of X means that they cannot be both true, then it is either X or non-X. So this implies in a certain way that we really only need two deontic modalities. The obligation, that can be the obligation of doing something or not doing that something, and the permission, which is the allowance to do something and the contrary of that something. And this is in a relation of contradiction. Next one, please. Well, I'm not saying anything new. On the contrary, this is very well established. If you go to the early beginnings of deontic logic, that is more or less established in the famous paper from George von Riet in the journal Mind in 1951 with the same title, Deontic Logic. He already uses two operators, and most logicians in deontic logics use these two operators. But I think we have to consider that law is linguistically put. So there are some points in which we border logic and interpretation. After all this, and since this is a James session, I will not give answers, but make questions. The content of legal systems is totally contingent. It depends on the will of normative authorities. So we cannot simply ignore the possibility of a crazy normative authority enacting the following sentences. X is permitted and addresses have to guess the status of non-X. It's like if the normative authority would be playing with citizens, but it's as possible as anything else. And the second normative sentence is X is permitted and non-X is mandatory. These very awkward examples show a border between logic and interpretation. And my point, just for fun and discussion, is that in these two cases, we have to access like three different things. And these two questions, in my opinion, they somehow comprise the three packages of our project, because it leads us to a practical problem. What I do, what should I do given the law that exists? That's what I'm questioning with this last question. Is the solution regarding what should I do regarding non-X a logical solution, or this is just a matter of interpretation? And you can move to the next slide. And I thank you for your patience in listening to me. Thank you very much.
Thank you, David. I think that we, not only that we got the basic clarifications in the ontic logic, but we also got with this last examples that you provide us enough of the food for thought, or at least for this discussion today. So with that in mind, I open the floor both for the people in the room and the people who are following us online. Goran will be the first one to address.
Hello, David.
Hello.
Just one short question in the light of what you said. What do you think, or can you say something about argumenta contrario? Because it's familiar thing for jurists, more familiar than deontic logics and these kind of structures and relations between different propositions. Where is the place for argument a contrario in light of all you said now?
Okay, Goran, I think Pedro will address that topic.
Okay.
And, I'm not totally sure about that, but I suspect he will address the topic, so I cannot spoil his party.
Okay, thank you.
If you can talk after me so that you don't take away my presentation, that would be great. But if you want to, I know that it's something that you like, so go ahead.
I just want to say something. There are many different types of logic. Sorry?
No, go. I'm interested in hearing the answer.
There are many different types of logic. You have classical logic, propositional logic, which is the logic of propositions that regards the trueness and the falsity of propositions. And then you have predicate logic, and then you enter into modal logics. And in modal logics, you have a lot of different modal logics, and you have deontic logic, which also comprises many systems of deontic logic. There is standard deontic logic and other kinds of deontic logics, like, for instance, Kanger's reduction, and so on and so on. The problem that we can assign to the a contrario argument is a problem of propositional logic, not a problem of deontic logic. So it's a little bit outside of the scope of my presentation, but since I think it is inside the scope of Pedro's presentation, I will be moot on the topic, at least for now.
Okay.
Okay. Further questions? Yes, Jules.
Yeah, I think it is. Can you hear me?
Perfectly. And nice to see you.
Nice to see you too. So I would be also provocative with your last question. Where do you think the border between logic and interpretation is, if any?
Okay. Can you just move a slide to the 13? We are at the 14. We can move to the 13.
This one?
Let's look into the first sentence. The legislator, the normative authority, has enacted a statute, and in Article 1, he says, or she says, X is permitted and others have to guess the status of non-X. How are we going to solve this somehow epistemic problem? We don't know the status of non-X. So I would say that this is an interpretative problem. We have to know which is the status of non-X, but in order to solve this interpretative problem, we have to make use of logical skills. If non-X is not permitted, so the whole sentence makes no sense. But the issue is much more visible in the second norm sentence. X is permitted and non-X is mandatory. We have here a serious problem because this sentence somehow encompasses a contradiction. And we can only access this contradiction if we somehow understand the logical relations between the deontic modalities. So my point is, this is essentially a matter of interpretation, but in order to carry out this interpretation, we cannot dispense and not use logic. So I would say it is very difficult to define a border, but there are some indeterminacies in law that we cannot deal with them without using some logical knowledge. But if you ask me for a precise border, I cannot say what it is.
Okay, thank you. Pedro?
Thank you. I was just wondering with that example of X is permitted and non-X is mandatory. Perhaps you said the same thing, but this reminded me of the absurdity would mean the absurdity arises from the fact that the system would be pragmatically inconsistent. It's almost like I'm thinking of that example where you create a norm of competence, but at the same time you forbid any circumstance in which that competence could be exercised. Then the system would be pragmatically inconsistent. That's how you come to the conclusion that you need to have a default permission to exercise the competence. In this situation,
sorry to interrupt you. Do you think that having alongside a norm of competence and the prohibition to exercise in any circumstance that competence makes the system pragmatically inconsistent?
Some people think, I have claimed as well, but I think that would be the case if you create, but that I was just making a parallel. Don't go into the norms of competence, please. Otherwise, we will stay here forever.
Because the failure of the story is that if you say so, you are somehow assuming that power implies permission,
which I do. But it not the constitution. No, it's much more difficult. Now David's provoking me. Sorry, everyone. That was not my
the
fault,
best defense. It's the counterattack.
What I mean to say is that if you create a constitutive norm that confers power upon someone, but at the same time regulates that exercise of competence as forbidden in any circumstance conceivable, then the system is pragmatically inconsistent. I'm not saying that norm of competence entails permission. I'm saying that it needs to entail a default permission, otherwise it will lead to pragmatic inconsistency. But in any case, I was just using that as a parallel for that situation in which we would conceive the possibility of the normative authority just regulating the positive permission, but the negative permission would be equivalent to either mandatory or forbidden. That would lead to a pragmatic inconsistency of the legal system, because the positive permission would never be a permission per se. It depends, of course, of the concept of permission. So I was on your side. I was not criticizing that. I was just giving an example. But since you attacked, can I just ask a question, which I think that I already know the answer, but when you talked about interchangeability of deontic modes, the negation of prohibition. So how do you deal with the Bulligin's trilemma that the negation of prohibition can never lead to a permission because it would be trivial, false, or simply falsely deducting a norm from the
I think he's right. I think he's right, but
that needs amending the square.
Do you think so? No, because if you don't have a prohibition, which means if you don't have the prohibition, it means that it is pragmatically permitted.
But that doesn't follow. Yeah, if you accept pragmatic account of permission, okay, which I do as well, but it doesn't follow from the square. That is hardly a logical problem. What you're just saying is that if we don't say anything, then the pragmatics of silence are equivalent to permission. But actually, there's
Yeah.
nothing there. There's nothing there. So there's no. So the concept of weak permission is basically something that we just call it weak permission because there's nothing there, neither weak nor strong nor mild nor hot nor whatever, nothing. Right?
No, right?
Yeah. So that was my question. Yeah.
Okay, thank you, Nina.
Hello, thank you for your very interesting presentation. I was just curious, what would you recommend from a nomotechnical point of view? Should the legislator in the permissive norms always state what to do with non-X if X is permitted? Should everything be phrased explicitly? Or is it just safe to presume that if X is permitted, non-X is permitted unless it's specifically regulated otherwise? Because the way I think now, I haven't done any statistics or anything of the sort, but I have the feeling that legislators only explicitly state it when it's a particularly sensitive subject. For example, in the Serbian constitution, and I think there are similar norms in other constitutions as well, you have it expressly regulated that everyone has the freedom to express their national identity, but nobody is forced to reveal their national identity and so on. So nobody is obliged to do that. We could simply assume that if everyone is permitted to express their national identity, they are equally permitted not to express it. But given the fact that this could cause problems if someone misinterpreted such a norm as to say that the national identity revelation is mandatory, the writer of the Constitution put it explicitly that it is not. So what do you think should be done in such cases?
Well, thank you very much for your question, and thank you for your example, which is a very, very interesting example, because as far as I know, these kind of situations where the normative authority explicitly enacts the deontic status of both versions of the action type are very, very, very rare. It almost never happens. So that's a very interesting example. I would say that I think a lot about the perfect legislator. And what would the perfect legislator do if he wanted to enact very complete norms with all the information that we need? And our legislators, for many reasons of norm drafting, they give not that much information. Namely, when you have, I can give you just an example that I find it very interesting. I believe that norms create correlativity between different addresses. If, let's take for instance, the Constitution says that the state has the duty to provide healthcare to citizens. So you have two universes of addresses, the state and the citizens. But when you look into freedom of expression, the state did the legislator did not explicitly showed the two universes. He only says everyone has freedom of expression, and we do not know which are the people that are in the other side. So normally legislators are not informative as they should be. And we have to deal with it. And in my opinion, these are very strict questions of interpretation. But pointing out precisely to your question, I think, and that's something I addressed, that it makes no sense whatsoever, in my personal opinion, to consider that the use of permissive verbs by normative authorities is other than a bilateral permission. It makes no sense whatsoever, because if it is an unilateral permission that would imply that not being the non-X version of the action type permitted, that would imply that X is being obliged, which is totally devoid of sense given the terminology that is being used by the legislator. If the legislator says this action X is permitted, it would be very, very difficult to sustain that non-X is not permitted as well. So I don't think we can call it a presumption. We are not presumpting everything because presumptions are depending on norms stating the presumption. I just think it is an interpretative outcome that we take using the relations between the deontic modalities, the logical relations between deontic modalities. But I wouldn't call it a presumption. I just would call it an interpretative outcome that we do using this logical machinery.
Thank you very much.
Thank you.
Okay, Professor Hasanbegović.
Thank you. Thank you, David, for your presentation. It was clear and very straight and precise. And I thank you very much. I would like to add something also to the comments, and that will explain to me if I understood quite well. You differentiate between contrary and contradictory relations that are contrary and contradictory also in deontic logic. And in my eyes, that is the space when you can say, also answer to Goran, that is the room where we can find argumentum a contrario. So in both concerning contrary and contradiction, we see that in let's say ordinary logic and deontic logic as something that has to do with something a contrary. And also, when you say it is a question of logic and not of interpretation, I understood it as it is a question of analytic logic, either classic or modern one, but still analytic, and interpretation has always to do with the dialectic logic. That is to say, we cannot interpret anything only sticking to the rules of analytic logic, starting from Aristotle to these days. Maybe I'm wrong, but you can see also this second comment as a question to you, and the third one will be concerning this differentiation of permission on one side and something that is mandatory or obligation on the other side. And I would like to hear from you something about two kinds of permissions in legal life, in legal sphere, namely rights or rights and freedoms on one side as one kind of permissions, and competencies or let's say legal power or on the other side. because both of these kinds of permissions or empowerments are contrary to the obligation, legal obligation, or legal duty on or something that is legally mandatory. Am I right in this, let's say, addition to what you said, or not? That is just for me to make clearer your point. Thank you. Thank you once again for your.
I thank you, Yasminka, but who am I to say if you are right or wrong? I will just give you my opinion on that. Regarding the problem of the difference between contrariety and contradiction, I think I think, in my opinion, you're right. That's decisive on the analysis of the contrary argument. But once again, I will not touch the topic because Pedro will speak about it. Your final question is a very interesting one, but it leads us to very complicated waters, mainly because of the power conferring norms problem. I would say, and this is my position, and I have been thinking about these things for many past years, that powers, which is having the competence, are permissions. Well, which means that when we think about all Feldin categories and we introduce into the classification of rights the 4 types of rights he considers as rights, like claim rights, liberties, powers, and immunities, without addressing now the immunities point, I would say that all of them are legal positions that fall from permissions. I think power conferring norms are specific because they give the ability to carry out an action that would be otherwise impossible, which is to produce deontic consequences. But this power, this legal position, is by definition regarding the action type producing deontic consequences permitted. If it would make no sense if it were not permitted, which does not prevent the legislator to say, but this specific exercise of the power is not permitted, it's prohibited. That's another totally different thing. The power conferring norm, by definition, in my understanding, is also a permission. And liberties and claim rights, they also follow from permissions in my position. So I think they are exactly the same. And they are the legal positions that follow from permissions. The only difference is that first order norms, like normal permissions, they just regulate brute action, while in the case of powers, we don't have brute action. I'm sorry. We just have some action that is institutionalized, which is to produce deontic consequences. So I'm totally in accordance with you. I agree totally with what you just said.
Thank you very much. And if I don't bother you too much, because I see you you catch a cold.
No, I don't know what this is.
Some just a remark on this differentiation between logic and interpretation. logic as analytic logic and the interpretation that involves dialectic logic. The differentiation that starts also with Aristotle.
Okay, thank you. Are there any other questions? Any other questions or comments? Or maybe, David, you could come up with a more clear statement of yours on the question that you asked. Okay, before doing that, we have one more hand raised. Alexandra, our master student. Go ahead.
Hi, everyone. Can you hear me?
Yeah, perfectly.
Yeah, very well.
Okay, so just want a clear comment. I think my fellow colleague and Belgrade University assistant Nina Kršćanin reminded me of another norm in our system that has this spread, that it is also available, but also it is not, for example, it's not, it doesn't make you do it. Changing surnames when it comes to spouses. In our current system, spouses can take each other's surnames, can add each other's surnames, or not do anything at all. It is an interesting concept because it involves both scenarios at the same, multiple scenarios at the same time, and it's really a widespread norm. And it's similar to what she was saying about where your nationality is. So I think it's another example in our system. And because nowadays we have spouses taking each other's surnames, adding surnames, or not doing anything at all. And it's really this modern concept, but interestingly in the case of your topic.
Yeah, thank you for another example. I see that Serbian law is full of fruitful examples for this thing. But I would reply with more or less a question. Imagine that Serbian law said, you may.
We lost you, David. Or just video.
Portugal internet.
Nije Portugal, čovječ u Kaliforniji, brate.
Like Silicon Valley.
Silicon Valley just swallowed David. I don't know what. Yeah, maybe we should give him a minute or two to reconnect. Now he just left the call entirely. Hopefully with the idea to reconnect.
Yeah.
Are you listening to me?
Okay, now it's okay. Something happened. We just lost you, but you are back, thankfully. So you just started with asking a question. Imagine that, and then we lost you. Imagine that the Serbian lawgiver provides the following.
I was saying, you didn't listen to that. I'm sorry.
No. That was your words. You started. I just reminding you where you stopped at the moment when we lost you, because I don't know whether you were speaking. So I don't know.
I now understand that I kept on speaking to myself, but
I kind of presume that that's why I'm just telling you what we've heard, the last thing from you.
And the continuation was more or less this: is that's a very good example, but somehow it's not a claim, it's not a point, but somehow I see it that it is very, very difficult in my understanding to justify that when the legislator just says one of the two contrary actions is permitted, to not understand the other one as not permitted. So giving the example Alexander gave us, if the Serbian law said spouses may take the other one names, just that, without adding that they may not take if they don't want, I would say that the outcome is exactly the same. That's what I think.
Okay, and then we can turn to what I propose. Maybe you have kind of your specific answer on the problem that you posed. Would you go for the? I mean, is it more the question of interpretation, or the outcomes directly stems from the logic? What would you say yourself in this situation?
I would say that I somehow already answered this following Julia's question, but I think that in order to understand the meaning of these sentences, we cannot avoid to use logical tools. And by using these logical tools, we will understand that X being permitted and non-X being mandatory creates a contradiction. So actually, you would have to interpret these sentences as leading to a contradiction, and then we would have to solve the contradiction. So it's not a matter of it is a logical problem or an interpretative problem. It is a matter where interpretation is dependent on use of logical tools. And that was more or less what I wanted to show.
Yeah, interestingly enough, just to add to what you've said, in our kind of the older tradition in interpretation, in the sphere of interpretation, legal interpretation, scholars used to put an emphasis on a separate tool of interpretation that was called logical interpretation, which is, as you know, outside of this classical toolbox of the four, like textual, systemic, purposive, and historical interpretation. So what is the case? I mean, how would you assess this idea? I mean, we are no longer speaking really about logical interpretation, but what you said now comes rather close to what was understood under this label logical interpretation.
Well, Miodrag, I must confess that I never heard about logical interpretation.
No, as I said, it was part of our older tradition, namely in the 60s, 70s. Our old professors used to specify this type of interpretation exactly in the way you do it. So basically, you are relying on means of logic in order to get the interpretative outcome. That's the thing.
If we go back to the von Savigny system of Ortigan, Hamish, and Rest, and we look into those categories of interpretation that he used to make, there were no mention to logical interpretation. And I never crossed this idea because our old professor from the 60s and the 70s, I think in Portugal, they never used, I'm not very familiar with the idea, but nevertheless, my point is that I find the expression logical interpretation a little bit misleading because there are no interpretative outcomes which are more or less logical, I would say. My point is that some sentences enacted by legislators can only be understood and it can only be translated into some useful meaning if we just know how to use the logical machinery, and we can, I wouldn't say make some derivations, but we can understand which are the consequences of saying this or saying that. So I wouldn't call it precisely a logical interpretation, but I would say that there are instances of the legal domain where the answers regarding the meaning of words is very much dependent on logical relations. That's my idea.
Okay. Thank you, David. I think that with this, we can give you another round of applause.
Thank you.
And we can move to Pedro. So, Pedro, go ahead. The floor is yours.
You probably can just drop the presentation.
Okay.
I will gladly talk in your presentation.
You could share, but stop sharing.
No. I know.
That's better.
That's it.
Okay, so once again, it's a great pleasure to be here online. It would be a greater pleasure to be there. Hi to everyone. It's always hard to speak after David. So, and thanks for sparing me the a contrario thing. And I'm sure we'll have discussions on that, also with the questions that were posed. And well, my presentation will be a little bit more softcore, and I would talk on how can logic be useful for law practice, both on the theoretical side and also on the practical aspect of argumentation. And since this is a jam session, so I feel completely freestyle. Stop me if it is too much. I would jump in that discussion on logic and interpretation, because that would be my first topic. It would be the place of logic, what logic can give you and what you cannot expect from logic, because logic is not suited to give you. So logic is basically a formal science, truth-preserving science, truth-preserving scientific endeavor, at least in the more mainstream classical way of conceiving logic. And there are a lot of other ways and systems, peri-consistent logic and fuzzy logic, predicate logic, propositional logic, and modal logic and whatnot. But it is basically a truth-preserving, it basically has to do with truth-preserving reasoning. If we accept truth to be a part of the logic that we are using, which sometimes doesn't happen with other types of logic. And so the first topic would be that there's some prejudice against logic. We can, if we go back to Oliver Wendell Holmes Jr. And his famous quote on The Path of Law, he claims that law has not been logic, it has been history. So he criticizes what is called the logic theology, those who have faith, maybe irredeemable and unsurmountable and excessive faith in logic. And I think that has sometimes had a boomerang effect of an unjustified and unwarranted prejudice against logic. So we need to balance this out and first have a clear idea of what we can expect of logic, of what we can expect of logic in legal reasoning, what it can give us, and what we cannot expect from it, because we would be actually, it would be an illogical argument. We would be maybe hyper-rational because we would be asking of logic what we cannot demand of other things, and we don't ask interpretation to give us every possible valid outcome of legal reasoning. So why should we ask logic to give us that? So basically, we cannot expect logic as a truth-preserving science to give us anything at all on the strict concept of interpretation. Insofar, we accept that interpretation is an ascription of meaning to legal texts. So, but we can use logical tools, and I think that was what was being discussed, on assessing contradictions between ascription of meanings that may or may not violate rules of interpretation, which is a completely different thing. So we can't expect logic to give us something on the conventional meaning of cat or dog or dangerous or group or sexual misconduct, but we can use logical tools to assess contradictions between interpretative outcomes and those interpretative outcomes that are imposed by us by means of rules of interpretation. So this is again of paramount importance. Logic, and it has to do with the connection between logic and rhetoric. So rhetoric should start where logic can no longer solve problems. Of course, theoretically speaking, and if we go back to Nelson Goodman, the rules of logic and inferential rules themselves are subject to acceptance. So this would be, if we go back, so we are basically saying that, okay, we have deduction, induction, abduction, the basic inferential rules, and we accept them as sound, but those rules themselves are subject to acceptance by a relevant community, which would lead to an infinite regress of how do you interpret deduction and what is deduction and so on and so on. So if we stop in those basic rules of logic, they will give us the sound ground that we need to have proper legal reasoning. And when logic does not give us any sound or solid ground for reasoning, then rhetoric and persuasion of a certain audience begins. And this, of course, is a very is a theoretical way of conceiving of it, because it is not necessarily the case for lawyers. Maybe lawyers have success in using persuasive arguments, persuasive rhetoric, trumping logical arguments for the other side, which is a very relevant thing as well, because when we talk of logic and logical arguments, then you need to take into account also the placement of arguments, which is a completely different thing, how they reflect upon the person that you are trying to convince. But again, this is something that, theoretically speaking, should start after sound logical arguments can no longer give you a good solid ground for warranting your conclusions. So in this place of logic, how do I or we, it actually depends of how one wants to use logic. I am not a logician, so I try to learn logic and use logic to the extent it provides me the tools to have sound conclusions in legal reasoning and legal argumentation. How do we use it? How can it be useful for us? And what we can draw from it. And so I just chose randomly some aspects that I think logic can provide us with a good toolkit for argumentation. So the first one would be still in this division between what logic can give us and what logic cannot give us, is the differentiation, a classic differentiation by Jerzy Wróblewski between internal justification and external justification. So logic, in the classic sense, can only provide us with, well, this is actually not entirely true, but in the legal reasoning, logic is mostly focused on internal justification. So how you can derive conclusions from premises. Either you deduct them, or you induct them, or you abduct those conclusions from the premises. And that depends on whether one is saying that if the premises are true, then the conclusion is true, then you are deducting, because the truth value of the conclusion is implied in the truth value of the premises. Or you just may be saying that the conclusion is probable or highly probable, and then you are inducting. Or you may be abducting when you are searching for a cause, when you ascertain that a certain outcome has taken place. So when the conclusion has been ascertained and is taken as a premise, but you want to conclude on what was the cause of it. And then this leads to another important part that I will I'll leave to the end of my very anarchic presentation. That would be logical fallacies. Because when you are abducting, you may be incurring in the logical fallacy of causation and correlation. You may be just assuming that a certain cause was the cause of a conclusion that one has ascertained, but actually it may be just correlated with that, and it was not conditio sine qua non or reasonable condition for that conclusion to take place. So this is the first aspect, and as I was saying, it is not entirely true that logic only deals with internal justification. It also can deal with external justification, which is the soundness of the premises. Because the premises, it's very easy to logically conclude or validly conclude for something if the premises are taken for granted, but then we need to ascertain the soundness of the premises. But the soundness of a premises most likely is also a conclusion of another set of premises. So the external conclusion is naturally subject to internal justification as well, and there we can use logic as well. So it does not, one is not required, and this is something that I would like to point out. One is not required, even though I think it's highly important to have a strong logical toolkit. One is not required to have full knowledge of propositional calculus to use what is called informal logic in legal argumentation. And then it leads us to a lot of legal arguments are actually not even logical arguments. We use, for instance, I'm going to speak a little bit about argument a contrario. It is actually not an argument. It's just a logical conclusion. And I think that David will agree with me on that, right? Argument a contrario is something that we call argument, but actually it is not it is the interpretive argument that we use as a pre-requirement for a logical conclusion. The a contrario is basically the conclusion itself, right?
Yeah.
Yeah. So, but I'll get to that later on. So, apart from this, how can logic be of use? And I pointed out four specific topics, some of which were already mentioned before by David. One is the mapping of conflicts, which is a very relevant aspect of legal argumentation. Logic cannot, again, we cannot expect logic to help us solve legal problems. Logic is not of use in providing us with the answer of solving legal dilemmas or conflicts, but logic is extremely relevant on mapping possible deontic contradictions, possible or necessary deontic contradictions, because I think they are necessary, but I'm just saying possible because it depends on what we are thinking of, or legal cases, or legal cases that instantiate legal norms that are in overlapping contradiction. So again, we can use the logical toolkit to ascertain a given normative conflict, but we cannot expect logic to help us solve that conflict. And we cannot expect as well, because that would be asking too much of logic and that would be a fallacy, to use strictly the toolkit of logic on mapping legal conflicts, because mapping legal conflicts or normative conflicts presuppose as a pre-requirement the ascription of meaning to legal texts. And the ascription of meaning to legal text is a matter of interpretation. So if we use the classic notion of Alchuron and Bulligin on the difference between the master system and the master book, what we have when we look at the legal system, we have the master book, which is the bundle of legal texts that do not contradict among each other, because texts do not contradict. But then you take the master book, you interpret it, which is a matter of high complexity, because then you have theories of interpretation that are more or less sound. You may be originalist, you may be proposivist, you may be textualist. That actually it's the best possible solution to be textualist, I think. But then with that ascription of meaning, you pass from the master book to the master system. And when you are at the level of the master system, you're dealing with norms. Of course, you have to use language to refer to them, which is a nuisance, but that's the way it has to be, because you need to reinterpret, because when you're making reference to a norm, you're using language as well. But there is the moment where you use logic to map normative conflicts. But you do it together with semantics and perhaps to a certain extent pragmatics. Otherwise, you will not be able to grasp the meaning of legal texts. Therefore, you will not be able to map normative conflicts. And if you're not able to map normative conflicts, then you are not able to reach the certain conclusion that, for instance, the outcome of a certain legal norm should prevail over and reduce the scope and defeat a conflicting legal norm. So that is highly valuable to have knowledge of logic to reach these conclusions. And again, at the argumentative level, it is very important to flesh out all the premises of your reasoning. So using logic at this certain step of the argumentative process It's very important because it presupposes that you flesh out, that you do not leave any enthymeme logical concept. So you do not leave any assumed premise or underlying hidden premise. You just flesh it all out. You put all the cards at the table, and logic helps you in that specific moment where you are mapping normative conflicts. And the second topic is related to this. It's related to a theoretical endeavor, but also with practical consequences, which is the issue of the feasibility. The feasibility, basically, it's the dispositional property of norms that makes them liable to be defeated under certain factual or legal circumstances. How is logic relevant here? It is relevant not only because it is with the help of logic that you structure legal norms, but also with taking into account conventionalism, because it is of no use that one has a certain account of the structure of legal norms if the remaining relevant community has a different concept of it. So you need to take into account conventions as well. But logic is also very relevant at this part. But how does it help on the feasibility, and why is the feasibility relevant? Because in legal argumentation, just the mere fact that, which I believe to be true, all legal norms or all norms, irrespective of their source or system in which they are included, are defeasible, is a matter of logic. It is a matter of logic, because if it irrespectively of the account that we have of separate norms, what is called the individuation of norms, it is actually quite easy to conclude that if norms have a certain antecedent, have a certain fatty species or protesis, some requirement for them to be applied, then it means that the conclusion is grounded on the requirements of the antecedent being fulfilled. If the conclusion is grounded on the antecedents of that norm having been fulfilled, irrespective of the content of the norm, either it is the protection of human life, highly valuable and exceptionally relevant within a legal system, or just a rule of a social rule of etiquette that a man should take off his hat when a lady enters the room, irrespective of the content of that norm is liable to be defeated under certain factual and legal conditions. It doesn't matter whether it will be defeated. It may never even ever be defeated. It has the dispositional property, it has the ability or the passive aptitude to be defeated by any other norm that may be instantiated by the case at hand. And why is that? It's also a matter of logical reasoning, because the simple fact that a norm has a requirement means that that norm cannot at the same time provide for its applicability, which it does. It has requirements, so it provides for its applicability, but it cannot provide at the same time for its all things considered effective application. That is necessarily the consequence of other norms or rules, to put it in a loose way, of a legal system. Because you cannot ask a norm by itself to govern its own conditions of definitive application. It would be the same as if we can put this either in the military hierarchy or the academic hierarchy. Like, I cannot go into my law faculty and say, listen, I'm a full professor because that's what I decided. No, that needs to be decided by higher ranked professors that confer upon me the ultimate application of my academic rank. The same happens in the military. So again, the feasibility is basically a conclusion that one can reach with the aid of a logical toolkit, but also can be applied with the aid of logical toolkits, because it is after assessing that a certain norm, as all are, in my opinion, defeasible, that we can assess the conditions in which those norms can be defeated. So that is the second aspect that I wanted to point out. And well, the third aspect, it would be the third and the fourth, but I will just bundle them together, is how can we have logic in helping out with legal arguments, which are more or less logically rooted, either in informal logic or in more sophisticated propositional logic. And I divided this two aspects of legal argumentation and logical fallacies. And we have, for instance, many arguments that are labeled legal arguments are purely logical arguments. And what happens is that lawyers usually, and I have nothing against lawyers, I am as also one, they basically learn that those arguments are legal arguments when those arguments simply are the application of logic to legal data. So there's nothing legal there. It's basically purely deduction, induction, abduction, wrong use of deduction, wrong use of induction, labeling as deduction when something is actually an induction, and then the specific kind of arguments that we have when we read legal decisions. And I've selected argument a contrario, argument a fortiori, and argument a simile, which would take a lot of time to discuss, so I'll just pinpoint some aspects of how logic can help out in making these arguments explicit. So, starting with a contrario, and again, it is actually not an argument, because you cannot, it is not the application of the contrario that is being discussed. It is something that is before that, which is whether or not we should interpret this legal text, this legal provision, as being liable to a contrario, what classically is called to find the jus singulare, to find an exception. And that is what is under argumentation, what is under debate, not the conclusion that from an exception you may reason a contrario, not the conclusion that from jus singulare you can reason a contrario. And in logical parlance, what we call jus singulare is a biconditional. So the issue is simply whether to take into to use Fred Schauer's well-known examples of whether dogs are allowed in the restaurant. The issue is whether one should interpret dogs are not allowed to enter the restaurant as a if and only if dog is not allowed to enter into the restaurant, which is a biconditional. And if we ascribe that meaning to the provision, dogs are not allowed to enter into the restaurant, then we can validly derive the conclusion that we can enter into the restaurant with elephants and bears and tigers and cats and scissors and whatever. But if we interpret that provision as a pure conditional, not a biconditional, then that provision is necessarily, or the interpretative outcome of that provision is necessarily just an instantiation of a higher justification. For instance, no animals or living beings that may jeopardize the well-being or the peace of the restaurants may enter into the restaurant. And in that situation, you cannot reason a contrario for the same reason that you cannot derive a permission from a prohibition. So what I was mentioning before when David was presenting the Bulligin's trilemma, you cannot derive a positive in the sense of strong, in the sense of normative permission from the negation of a prohibition, in the same sense that you cannot validly derive an a contrario deontic status from something that is not a biconditional, so from a pure conditional. So this is how logic can help with the a contrario. Another one that is highly relevant, and I think it just keeps on being more relevant in my eyes, which is the a fortiori argument, has to do with using logic to preserve consistency in legal reasoning. And this is actually, if we read legal decisions, judges sometimes are not aware that they are being inconsistent. So sometimes they are even unfairly criticized because they are not aware that they are holding inconsistent conclusions. And the a fortiori argument, when it is fleshed out with the help of logical toolkit, can be very enlightening in preserving not the truth of premises and conclusion, but the consistency between premises and conclusion. Perhaps even the coherence, which is an entirely different issue, but I will stick to the consistency here. So how does the a contrario work? Well, you need to ascribe certain metrics, you need to have certain requirements to conclude in a fortiori reasoning. And even more than giving out the concept or the account of the a contrario reasoning, it's easier to give an account of how it works. It's very easy to say that if Pedro can speak more than 45 minutes on legal philosophy, then a fortiori Pedro cannot speak more than 1 hour because it is implied. So that's the basic issue. Sometimes it has to do with alcoholic beverages. If Pedro cannot tolerate 3 shots of whiskey, then a fortiori Pedro cannot tolerate 5 gallons of vodka, to the extent that the measurement that is in place is the degree of alcohol in Pedro's body. So this is very easy to understand in general. Not so easy to use in legal argumentation when it takes into account permissions and prohibitions and obligations, because the a fortiori varies in accordance to what deontic modality is being used in a certain case. But if we are able, and again, this is not a matter of logic, it is a matter of interpretation in its larger sense. If we are able to grasp a certain metric that is being used, either the intensity of restriction to fundamental rights, either the promotion of well-being, or whatever is the case, and if we use it, so again, it's internal justification, not the external justification, because we need to externally justify those metrics. But if we take them for granted, then we can easily use a contrario, a fortiori, by claiming that if a certain provision ranks in the scale of, for instance, 7, in the metric of restricting fundamental rights, then a fortiori, another provision that ranks higher than that cannot be allowed if the first one was not allowed. So, but if the first one was allowed, then that one, sorry, it's the other way around. If the first one was allowed, then the second one, a fortiori, must be allowed. But if the first one was not allowed, it doesn't necessarily follows that the second one will be allowed. So there are some fine tunings that need to be done in the a fortiori argument. And the third one would be the analogical reasoning, which again is basically, and I don't want to take too much time on this, but basically it also has to do with taking certain causal relevance as warranted and transposing it to to the target that is being subject to analogical reasoning. And again, it is not the place of logic to say whether that was or not, whether that has or not a certain causal relevance. So logic has something to do with that, but it's not logic itself that determines simply what is the causal relevance of dogs jeopardizing the well-being of people eating at restaurants, because that has to do with empirical aspects of knowing that a certain breed of dogs may or may not be noisy or bothering people and stuff like that. So these are the third. This is the third conclusion, the third aspect of logical argumentation that I thought would be relevant. And to wrap up, because I'm taking a bit of time, I will finish off with logical fallacies. So how does logic play a role in legal argumentation? By means of detecting logical fallacies? And I would have like a lot of examples to bring out, and I'll just throw some subjects for discussion. I chose begging the question. Basically, when someone is arguing with incircularity, so that is one logical fallacy, or petitio principii. The second one is the slippery slope, which is very powerfully used in rhetoric to scare off a certain audience. Take into account, for instance, when discussing the highly problematic aspects of euthanasia, you have that argument that scares off the audience that if euthanasia is accepted in an extreme case, then a culture of death will fall upon us, and we will be accepting in this kind of weird Kantian way the culture of death over life. And that is, of course, a logical fallacy, because there is no connection between the exception with small scope that you may be opening up and the outcome that is merely being used to scare off a certain audience. Another logical fallacy that reminds me is that it is the fact that we say that exceptions prove the rule has a logical reason for that. Is whenever one carves out an exception, one is accepting and endorsing the general rule. So logically speaking, if we accept euthanasia in certain exceptions, we are accepting and endorsing the general rule. We are not changing paradigms. So you see, there's a lot of logical fallacies being thrown around, which are actually contrary to what logic tells us. Because to accept something as a certain exception that implies reinforcing, not debilitating. That implies reinforcing the general rule. And then we have false cause that I already spoke regarding causation and correlation. And the other aspect that I find logic to be extremely relevant in legal argumentation, even though it plays a role together with other aspects of pragmatics as well, is the issue of the burden of proof. So that would be also something that would take a lot of time to speak about, but I'll just leave us with the classic example of Bertrand Russell's teapot. The fact that you cannot use something that may be implausible, even though it is not subject to being refuted or rebutted, as is the fact that a certain teapot is now in the orbit of Mars, as a sound, valid claim, because it cannot be subject to evidence that that is not the case. So this is used not only in highly sophisticated philosophical discussions regarding the existence of God and whatnot, but also in legal argumentation. The burden of proof and division and the placement of the burden of proof is extremely relevant. Not only it has a logical background, but it conditions the outcome of logical conclusions, because even though it would be the case that I cannot validly contradict Bertrand regarding the fact that there is a certain teapot orbiting Mars at this precise moment, it is exactly Bertrand Russell's claim is that that would be highly implausible. So the burden of proof lies on the side of one that is affirming that argument and not the one that is opposing. And so I will stop here, and these are just, like the song goes, a few of my favorite things. Thank you.
Thanks a lot, Pedro. This was a really great connection between the problems that we discussed so far and expanding it to the areas of legal reasoning and argumentation. And I'm sure there are a lot of issues that are now intriguing enough to kick off the debate. So I'm opening the floor for questions. Actually, the guy on my right side, I'm not sure about his name, but he wanted to. Would you like to present yourself, please?
Thank you, Pedro, for a great talk, and thank you, David. It was a pleasure listening to both presentations. David make his forceful, narrow argument that was very convincing from where I'm sitting, and I think it was convincing for at least in the way the questions were presented for most of the people here. Now, I really enjoy this presentation. I have some alternative renditions of the role of logic in law, and I want to put forward a couple of them to see if you agree, because and I had a million fantastic ideas, and since we didn't speak about logic and law 2 days ago while we were having dinner in Portugal, because the kids were all around, now we definitely have the chance, and we'll have the chance in the next 2 years. But my problem was, with all the ideas that I had during your talk, was that at certain points I think that you painted the picture of logic and law as a bit too narrow. At certain points I think that you painted it a bit too broad. So this would be my first point regarding the narrowness, for example, of logic. So I think you did a great job, quite correctly, pinpointing the fact that Wróblewski was basically right when he was claiming that you have an internal and external justification of judicial decisions, and that you have now an internal justification of judicial decisions. And you were mentioning the possibilities in this sense, and you mentioned abduction, deduction, and induction. But basically, I think that the right rendition of the external justification of judicial arguments is basically deductive, and I'll explain in which sense. And that the internal justification is basically abductive. And I'll explain shortly in which sense. And you just left it kind of out of the discussion, and I think it's really important because that's where the interpretative part comes in, actually, and the evidential part comes in, for example. Because when we deal with the external justification, the internal justification can just follow basically the rules of deduction or modus ponens or whatever is used in order to reach a legal conclusion. So the idea is basically that both in the normative premise and the evidential premise, you use abduction in order to arrive at the best explanation either of the evidence or of the textual, so to say, evidence, or to arrive at the best rendition of the meaning. And usually that follows well, I think, the way we do things in law. For example, when judges argue, they usually argue about two interpretations or their best renditions of a meaning of a legal text in order to arrive at two different norms. Those are abductions because judges use whatever tools they find, for example, co-text, context, intention, dictionaries, or whatever, in order to arrive at the premises in this case. Then eventually it becomes a matter of just filling in the premises in this deductive argument, and I know it's an oversimplification oftentimes to present it as this Beccaria's idea of a deductive argument, but I think this could be important. That's how I arrived to this point. Well, I think actually that if we view logic as a critical standard of evaluating legal reasonings, it's far more useful than if we treat logic as a tool to be given to judges and lawyers in order to do their reasoning. I mean, logic has been around for a long, long time, and judges and lawyers are still profoundly illogical. So I don't think that we're doing like a fantastic job in promoting this, but I think we do a fairly good job in criticizing the existing argumentative practices of judges and lawyers. That's one thing. The second thing is, I think, when you were mentioning logical fallacies, especially this thing when you said that there is a role for logic, an important role, you said in the assignment of burden of proof. What I was kind of interested in is the renditions of the burden of proof and evidential arguments in terms of statistics, basically, more than in terms of logic. I mean, in the sense that, like, you have this thing where you do these abductions, but the level of certainty that you have to achieve is, I think, better rendered in terms of kind of these statistics than in terms of logic. I mean, humans are bad at statistics, at least as bad in statistics as in logic. So it doesn't make much of a difference in terms of the real life reasonings. But to my mind, there is a better chance, I think, for example, in statistics, to find some renditions of burdens of proof and these reinterpretations or explanations than in logic. Many other things that I would love to discuss, but yeah, those are the main ones.
That would take another 2 years of our project. Okay.
Yeah.
So go ahead, Pedro.
You're muted, Pedro. Muted, you have to unmute yourself.
Okay, so I was cursing. Now it's just a good part. Thanks a lot, boy. And those are very, very important questions. And thanks for giving me the opportunity to touch base on those three aspects. So I'll start with the second in a very non logic or chronologic way. How why do I place my faith in logic to have better lawyers or better judges? So I don't know if this is a valid conclusion, but I think that you don't want to like lose your job on criticizing the soundness of legal decisions, right? So my argument would be, yeah, it's true that logic is best used as a way to scrutinize and criticize legal decisions or judicial decisions specifically, but why not? Why do you need to use it? Why do we need to use it on a pathological way? So we can provide logical toolkit to lawyers and not to lawyers. It's basically judges, because lawyers do whatever they can to come up with in convincing the judge of a certain outcome. So it doesn't mean I'm not committed to any prophecy that judges will be more logical. That's why I started with Wendell Holmes. If you talk to a judge, like only 1 out of 100 will probably be interested in logic. The other ones will just say that you're a cold, heartless man that is more interested in these matters than in justice and human rights. But at the same time, if we can provide them with a very basic toolkit, then we might improve the soundness of legal decisions, even though that may cost us our job in criticizing those decisions. But you said something very, very important in the first part, and it's true. I left out the abduction and the inference to the best explanation as something that grounds the empirical aspect, evidentiary aspect, which is usually referred to as a matter of inference to the best explanation, but also, and I fully agree with you, with the ascription of meaning to a certain legal text. That is also a matter of abduction and inference to the best explanation. And it goes actually way, way back. So it's not only the conventional aspect of the meaning, it is also the inference to the best. I mean, I don't want to get Dworkinian here that you need to take legal philosophy into deciding each and every legal case, but you do need to justify externally, and that is a matter of abduction and inference to the best explanation, what theory of interpretation you're using, why, for instance, textualism is better than originalism or purposivism, objectivity and subjectivity. So that should be firstly ascertained, but again, this is not a problem of case by case. I think that is something that can be generally ascertained as the best theory of interpretation for the interpretation of certain texts. So it may not be interpretation of other legally relevant behavior, but legal texts can generally be defined as interpreted under a certain theory of interpretation. And that is a matter of inference to the best explanation, because you are assessing the soundness of that theory of interpretation as opposed to contrasting it with the unsoundness of other theories of interpretation. And then the matter of evidence, the instantiation of the requirements of the legal norm by certain factual aspects of the case, also a matter of inference to the best explanation. So I fully subscribe what you said. And that is, in fact, actually it makes me think, for instance, in that famous Alexi formula, the reliability the way it is applied to the interpretative conclusions is something that is also a matter of degree. I think that judges ought to take into account if they're certain that a certain relevant community ascribes a certain meaning to a certain legal text, if that is plausible, but perhaps it's not the case that that text would be understood by the majority or the vast majority in a certain sense, or if it's just a very implausible yet not completely false way of interpreting the legal text, and that also is a matter of inference-based explanation. So just the third aspect, how does logic deal with the burden of proof? I think you are right, but that, in the way I see it, does not dismiss what I said. Statistics plays a large role there, but that just means that induction also plays a large role there. So the fact that I find it highly implausible that a certain teapot is orbiting Mars at this precise moment has to do with, and you know that I like generics, has to do with the generic statement or the truth of the generic statement that teapots don't orbit planets. And there are two ways of me reaching out the conclusion, the generic conclusion that teapots do not orbit planets. Because I'm not saying that there's no teapot whatsoever that may orbit a planet. I don't know. I'm just saying that teapots don't orbit planets, but as a default rule. And that can be one of two, there's two ways of getting there. The first is inductive, because I've seen a lot of teapots and they were not orbiting planets. And that's a requirement for me to place the burden of proof on the other side. And the other one, which is much harder to explain, but maybe more correct, has to do with the theory of kind of fidelity to world structure. This is actually maybe more related to linguistics than to logic. It's because this statement is mirroring a certain fidelity to the structure of the world, which is a structure that has some kind of probabilities, and it is highly improbable that a teapot is orbiting the world. So this second option, maybe not that logic. The first option of induction, logic would get us there.
Thank you. Further questions or comments? Yes, go ahead.
Maybe you can,
yeah.
perfect. No, it's fine.
Hello, sir. I have a question concerning the logical fallacy of the slippery slope. My question is, isn't it a bit simplistic to say that during policy making, a certain policy can have very complex sociological consequences on the society at large? And how come that we can, within the system of logic, simply wave off a concern such as a distinctive change down a certain policy-making path by the within the system of logical analysis?
Thank you very much. I'm not. First, I wanted to be sure if I'm replying to what actually you asked. So, would it be simplistic to use a system of logic for policy making that has a lot of implications in that was the question, right? Okay. So yeah, I wasn't actually saying what I was saying is that you need to take into account logical tools, induction for instance, or abduction, in this case perhaps even abduction, that a certain something is cause for a certain outcome. So take the example of euthanasia. It would be liable to the slippery slope argument, someone saying if you exceptionally accept assisted suicide, then that leads into a culture of death. So logic is there for not only explaining or help explaining that a certain exception does not carve out the application of the general rule. It is basically an exception which is a different thing. And it is there, together with the claims on causal forces, to say that it is not, you have not proven that a certain exception leads to that outcome that everyone wants to avoid, which is endorsing a culture of death. So that was basically my claim, that logic and this fallacy can be used to debunk this logic can be used to debunk fallacious arguments such as the slippery slope. Naturally, when you are making policy, you need to take into account that a certain legislative measure or decision will have impact on several aspects that are not even foreseeable. So what you need to take into account, there is probability, which is also something that is related to logic, but you need to take into account that certain outcomes are probable or are improbable. I always remember this situation, I think it was in California, that coyotes were eating a lot of lambs and were getting the shepherds out of business, so they're unemployed because they were without the lambs because the coyotes were eating the lambs. So the government decided to give money to people that would kill the coyotes. And so the people bred more coyotes. So they bred coyotes to kill coyotes to get the money. So the number of coyotes rose, and it was worse off than it was before. So that's the problem of probability, not necessarily the problem of the slippery slope. Thank you for your question.
Thanks a lot. Further questions or comments? Yes, Jules?
Well, it's kind of a clarificatory question, because I think I heard you say something on the likes of that the argument a contrario has something to do with constructing exceptions.
Constructing exceptions?
Yeah,
No.
yeah, no, okay.
But
because I was going to ask in which sense, because as I know, the argumento contrario, it's used not to build or construct exceptions, but to construct norms for filling gaps, or to in this legal constructive variant of the argumento contrario, or to block the possibility to apply some norm.
Thank you, what I probably said was that the argument a contrario was not, it is not an argument. It is based on the argument of an exception, of the interpretation of a given provision being an exception. So if you interpret, you cannot, if you interpret dogs are not allowed in the restaurants as an exception, as a biconditional, if and only if, dogs, then it is not allowed to enter into the restaurant. So the exception is a pre-requirement for you to derive logically that you are permitted to enter into the restaurant with any other type of animal. So it is not to construct an exception, it presupposes that a biconditional is ascertained in the interpretation of a given normative statement. That is what I meant.
Okay. Any other comments? Yeah. Sala.
Thank you very much, Pedro, for this excellent presentation. Just to follow up briefly on Bojan's question regarding the external justification. When we speak of the norm premises, normative premises, or factual premises. We speak of proof when it comes to facts, and we speak of the questions of interpretation when it comes to the norms. But also, we could say that we speak of relevance when it comes to both premises. So it's the question whether or not we've chosen the relevant facts for the case and whether or not this norm, the legal norm, is relevant for the facts. So could logic help us in that sense, or is it completely a question of interpretation? That's it.
Thank you, Sava. That's
or can I just add? Sorry, Pedro.
Sure.
I mean, it's interesting because you were not present on the very first day we started with Andre. It was really the most improvised jam session so far. So there were a lot of questions for the audience. And at some point, we were discussing exactly the status of this mixed or compound, the conclusion stemming from mixed premises, you know, the normative and the factual one. So the question is, if you go back to what you've begin from, the thesis that logic is truth preserving science, or so it is normally called, then how can we account for the fact that the products that we are operating with, like judicial decisions, are never called true or false, and presumably they are relying on logic, right? So maybe that will also add to this question. And as I already took the word, just another thing with how can we account for the status of certain provisions, most commonly in human rights law, which are called absolute human rights, from which no exceptions are allowed? How can we account them within your account on the feasibility of all the norms? Would that be the outcome then exclusively of one way to interpret and apply those norms, or to treat those norms, and nothing that has to do with the logical status of those norms? Thanks.
Thank you, Miodrag. Thank you. Very, very interesting questions. So I will leave the relevance aspect that Sava asked to the latter part. So the first one, yeah, it's the Jorgensen dilemma that legal norms do not have truth values, which I basically find very convincing. So I use logic to normative propositions. So it's basically the truth of normative propositions. And I should add, but this is just my opinion, that and Jules is there, and I'm influenced by the Genoa school when it comes to certain aspects of theory of interpretation, even though I'm not saying that what I say is completely based on what is stated by the representatives of the Genoa school. Actually, when you're interpreting, you're not just saying that legal text is norm, that legal text A is norm A1. You are actually claiming that legal text ought to be interpreted as norm 1, which is a decision. And that actually follows from Ricardo Guastini, I think, theory of interpretation. It's an interpretative decision. And decisions are also neither true nor false. So interpretative statements are actually valid because themselves are legal norms, not legal norms, but they are norms because they are ought content.
That is very disputable.
I know. That's why I started off by saying that it was just my opinion, but I stand by it, and I shall not be afraid just because you said it was highly
and said it from California.
I know, but that's when it comes from California, it's even
It's even less forceful.
your credibility, sorry, David, it's stemming out of California. It's not that high. No,
It's not an argument of authority and not an argument of lack of authority.
Yeah, which is the logical fallacy. But I was saying this. So this was just my idea that interpretative statements are also subject to validity, because they have to do with compatibility or conformity with interpretative rules. So if you have a relation ascertained between a decision to interpret in a certain way and an interpretive rule, then you need to have a link of validity instead of a link of truth or falsehood. But in any case, irrespective of this opinion, I would be willing to. I don't accept the truth value of cognitive interpretation, because there's nothing to find in a legal text. You ascribe the meaning. That's why I made reference to the general school. But at the same time, it would not be a problem because using truth there, it would not be a problem because we are using propositions, interpretative propositions, and propositions are liable to be true or false. So that's the first question from Miodrag, and the second one, which is a common question, as you may imagine, because I've been labeled as a lot of terrible things for being together with my friends David and George, who has joined us, a defeasibilist, so someone that is
against human rights.
Yes, so it's being confused as someone that opens.
You like this qualification?
Yeah, he likes it.
Yeah, so I'll turn it against you, Miodrag. I'll try to turn this against you and say that no, my friend, you are the one who are endangering human rights for this, and of course this is a joke, but the argument goes as follows. It is the defeasibility of human rights that allows for those human rights to trump other human rights or objective constitutional interests or whatever undisputed universal norms are at stake. So the argument can be easily reversed. Not only does the argument, so it's a straw man, the first, not your argument, but the usual argument against defeasibility is a straw man, because defeasibility doesn't mean that a certain norm is defeated. It is not implied. So there, for instance, this Italian scholar Claudio Luzzati gives the example of diamonds, and other authors I've discussed this with George as well. The resistance of precious metals can be a good metaphor for the resistance of certain norms. So absolute human rights, it's just a linguistic simplification for saying these are legal norms or legal positions arising out of legal norms that very, 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 very unlikely will ever be defeated or ought to ever be defeated. That is one thing. To claim that they are undefeasible would be simply to bypass the normative structure that they have. And it is the normative structure, not the content, which makes them defeasible. So think of diamond as the most resistant precious metal that exists. There's a theoretical point, or at least the theoretical possibility of another more resistant metal being discovered, or a certain metal which is not that resistant, but under certain factual circumstances may be weightier, may weigh more than that metal, and that suffices for the claim of defeasibility. I am not committing myself to the conditions under which that human rights would be defeated. So people always say, how can you conceive of the death penalty? I do not support the death penalty. Like I cannot think.
Pedro, let me just jump on this in this and say, I don't know if you know, but there is a Portuguese guy that wrote a book, and he has a footnote saying that because Pedro and I do say that the prohibition of torture in the Portuguese constitution is defeasible, he said that we defend torture.
Yeah.
And it is actually written.
And that was and that was a one-time thing when I defended. No, I never defended torture. Never, ever. And
So, but there is an sorry.
No,
keep
go
on.
ahead.
No, I think this is. I totally agree with what Pedro said, but I think this parlance of absolute rights leads to something that look like a cul-de-sac. You just have to think about the situations when the same general norm gives different legal positions to different individuals. And you might have the case that the legal positions of these individuals given by the same norm can conflict with each other. And if they conflict with each other, necessarily one has to be defeated, because in the final instance, it is his right or a right given by that norm that will be defeated, and the norm will be defeated even though it will win the conflict as well regarding the other individual. If some circumstance in life, my right to life enters in conflict with the right to life, with Pedro's right to life, certainly at least one of these two rights to life will be defeated for sure. And I think this proves enough about how defeasible these norms can be as any norm.
Yeah, and can I just add, before going to the question of Savo, that there's the argument is easily reversed again, because, for instance, with the pandemics, there was some criticism regarding the feasibilists, if we can call them that. For instance, I had the opinion that the government could restrict, even if proportionally, fundamental rights of freedom, of transportation, and general freedom to move into other places at the territory. And the argument was always, because you're the feasibilist and you're loosening the requirements for the protection of the right to, or the freedom to circulate. But it can be reversed. So, and the other ones on the other side are the ones strengthening the requirements for the protection of health. So it's easily, to the extent that most likely those norms will be in conflict. The issue is never the issue of the feasibility, because that is a given. The issue is how proportional, if proportional, that restriction is. So I think that, again, it's a straw man against the feasibility, and even more than a straw man, because what Miodrag was saying was not a straw man. Just a clarification that it does not, like the feasibility claim does not commit to the degree upon which a certain legal position or a certain legal norm will be defeated, which is an entirely different thing. And now I can go to Sava's question on relevance. You know, I would love to ground this purely on logic. I have a couple of books on the logic of relevance, but it is completely ununderstandable. So even for the logicians, the logic of relevance is a highly difficult subject matter. What I can say is that it is problematic in legal reasoning. Like you can use causal relevance in certain situations, but you cannot use it in others. And this, I think this is the case. Like, if you take Fred Shower's example that dogs are not allowed in the restaurant because this certain dog, Angus, a black terrier, went into the restaurant and made a lot of fuss and confusion, and other dogs will do the same, then you can ascertain a certain causal relevance there. But you cannot ascertain that in interpretative statements. So when it comes to the meaning of a certain normative provision, it is different. And at the same time, you cannot use that same causal relevance with permissions. I'll give you the example. You prohibit the entrance of dogs in the restaurant because you connect a cause and a consequence. Dogs will lead to high confusion and fuss in restaurants. So we forbid dogs to enter into the restaurant. But I ask the question, and this has to do also naturally with analogical reasoning. How do you use this, for instance, in same-sex marriage? How can you infer a cause and consequence in applying the permission, the freedom to marry between same-sex couples? It doesn't work the same way, because what you are taking as the consequence in a dog entering to the restaurant, which is the fuss, is taken for granted the causal relevance in the prohibition, to expand the prohibition to other instances of fuss and commotion and confusion in the restaurant. But it doesn't work the same way in permission, because if you claim that, and I'm just saying that you cannot use the same reasoning, not that you cannot arrive to the conclusion. If you claim that, for instance, is a matter of happiness, then you are not using it the same way, because you are not taking that as a cause and consequence. That is the consequence of applying the rule. So I have some confusion in applying relevance to permissions, because they seem not to work in the same way. What I can say, the relevance of relevance, is that it usually is a matter of interpretation, not a matter of logic, because you should only take into account, and I accept the thesis of descriptive relevance, not the thesis of prescriptive relevance. You cannot prescribe relevant properties that are not foreseen in the legal system, and relevant properties are foreseen in the legal system if they are foreseen in legal norms, that is, if they are interpreted as such from legal provisions. So that ultimately, you're right, it is more an issue of interpretation in the first part, even though you can then logically reason with relevance. As I was saying, in some situations you can use that relevance and apply it to the target. You can use the relevance of the source and apply it to the target. In other situations, for instance, with permissions, kind of seems harder, because it works better with prohibitions. I don't know if I was clear, but that was a hard question.
Okay, thank you, Pedro. I think that with this one we can finalize this round of jam sessions, and another round of applause for you. And I thank you all for joining this event. For those who are online, we will just now continue with the part on administrative stuff regarding the project. So you are in that sense free to leave, if that's the right modality to use.
But no, not really. Could be.
Yeah.
Under an obligation.
Free to leave, but not free to stay.
Yeah. And let me make a warm welcome to our friend Sampaio, whom we also miss here, but as with two other guys, hopefully we will.
He promised that he's going to come next year.
Boyan told me that you promised, that you made a unilateral commitment